Module 7, Part 1, Crimes Against Justice. Crimes against the administration of justice are any offenses that hinder or prevent the effective operation of the criminal justice system, such as law enforcement, civil and criminal court systems, and the corrections system. Bribery and the attempt or conspiracy to commit bribery or extortion are major crimes against the administration of justice. Bribery is the offering, giving, receiving, or soliciting of any item of value to influence the actions of an official or other person in charge of a public or legal duty. This bribery could be to exploit power for personal gain. It includes any party who offers and the party who accepts it. Some state statutes for bribery extend the crime to non-public persons. And this is loosely known as quasi-bribery. The Model Penal Code for its bribery definition forbids law enforcement and public officials to receive gifts from individuals that are subject to their jurisdiction. It forbids a public servant who has the authority and discretion over contracts or transactions to accept or solicit gifts from any person who has an interest in the contract or transaction. Commercial bribery entails the giving, receiving, or soliciting of anything of value to influence an employee or professional in the performance of his duties. This is what's known as a kickback. However, campaign contributions, gratuities, and entertainment are acceptable, but the issue is when there's a quid pro quo agreement. I do this and you do this. Extortion is the obtaining of money or property by threat to a victim's property or loved ones, by intimidation, or by false claim. Perjury, false testimony, and interfering with a law enforcement officer in the performance of their duties are also crimes against the administration of justice. Perjury is the making of false statements under oath. The proof of intent requires proof that the witness believes that his or her given testimony is false. Tampering with the jury process means the threatening or attempting to harm or causing of harm against the jury member. Witness tampering is illegal conduct with the intent to influence witness testimony. Some witness tampering statutes are designed to address actions by organized crime figures that have been facing trial. A statute that was developed to counter witness tampering was the Victim of Witness Protection Act in 1982, in which this act provided protection to witnesses throughout judicial proceedings. Prosecutors must prove the defendant knowingly engaged in intimidation, physical force, threats, misleading conduct, or corrupt persuasion with the intent to influence, delay, or prevent testimony. Suppressing evidence means the suppressing or refusing to produce evidence for a grand jury investigation. This includes those acting on behalf of the defendant. Suppressing evidence may include destroying papers or other evidence after one receives notice of a grand jury investigation. The defendant must have the knowledge of the pending grand jury investigation. The defendant must know that particular documents are covered by the subpoena, and the defendant must willingly conceal or endeavor to conceal them from the grand jury. Obstruction of justice is the act by which one or more persons attempt to or actually prevent the execution of lawful justice. The intent required is the nexus requirement. Nexus means there's a link or relationship between the defendant and the legal proceedings against him or her. For example, an attempt to prevent a law enforcement officer from arresting someone. Under the Model Penal Code, a person resisting arrest or fleeing a crime is not obstructing justice. Other examples of obstruction of justice include attempting to influence, intimidate, or impede any juror, witness, or officer in any court proceeding regarding the discharge of his or her duties, or the actual impeding or obstructing due processes within administration of justice. In terms of resisting arrest, the model penal code in some states indicate that an individual does not ever have the right to refuse force in resisting, or right to use force in resisting a law enforcement officer making an arrest, whether that arrest be lawful or unlawful. Some states do have provisions that allow an individual to resist an unlawful arrest by reasonable force. However, there's some ongoing disagreement to this. The accused rarely knows at the time of the arrest whether it was lawful or not. That's usually adjudicated at some point during the process, maybe even during appeal. The unlawfully arrested individual has other resources or remedies post-arrest, like I just mentioned, either including civil remedies for wrongful arrest or appeal of their criminal conviction. The crime of compounding and misprision of a felony are two different crimes. Compounding a felony occurs when someone refuses to report or prosecute a felony in exchange for some type of benefit or reward of some value. The defendant escapes conviction and punishment, but there's no deterrent here to future criminal conduct. Misprision of a felony is the act of failing to report or prosecute a known felony and taking positive steps to conceal the crime. Escape occurs when a lawfully detained or imprisoned person leaves custody before he or she is entitled to by due process. This is when a individual removes or attempts to leave official detention, fails to return to official detention following a temporarily granted leave. Escape also includes while in custody of a law enforcement officer, a jail, within a lockup or any type of correctional facility. The prosecution must prove the person was actually under arrest. If the arrest was not complete, for example, the defendant was resisting or fleeing, there is no escape. Contempt of court is any affirmative act or omission that obstructs justice or attempts to negate the dignity and authority of the court. It can be the disobedience of court orders, disruption of court proceedings, or others. There are 4 categories of contempt. Direct contempt is when the person resists authority in its presence. And this is a criminal act. This is criminal contempt. For example, a person uses profanity toward an officer of the court, and this is observed by the judge during the court proceedings. Constructive contempt, also known as indirect contempt, results from matters outside the court's presence. This can be a criminal or a civil contempt charge. For example, when a person fails to comply with the judicial order. Criminal contempt is an act of disrespect toward the court other than direct contempt. And civil contempt is a failure to comply with a court order that benefits another party.